They're not going to do shit. At the end of the day, they can't do shit.
If he thinks we can't do something, you're going to look at this judge and think I can't do something, young man. You're going to learn a big...
Today, we're in Judge Simpson's courtroom, and the situation quickly takes an unexpected turn. The defendant before the court made the decision to remove his court-ordered tether, apparently believing it would somehow improve his circumstances. Now he is standing before the judge requesting that his bond be reinstated. That level of confidence is striking because violating a tether is not a minor misstep, it is a direct signal of disregard for the court's authority. Rather than showing caution or accountability, the defendant appears unfazed, which raises serious questions about his judgment and grasp of reality. Situations like this make you wonder whether someone who openly ignores court orders should be given another opportunity, or whether the court should firmly close the door. Let's take a closer look at how this unfolds.
Court calls the case of the people versus Marquesi Hankey.
I would let him know. Your Honor.
Good afternoon, Your Honor. Attorney Kevin Masson, except one.
All right, it's your motion.
There's probably a motion to the case that previously hearing my client's bond, though strong privileges there suspended due to allegations that he cut off tether and contacted the complainant. Following that particular bond hearing, the instructed my client to not contact the complainant witness period in the jail. Also instructed my client if allowed to be back on bond, we would ask the court to hopefully reinstate his original bond, tether. I would note, Judge, that he has no prior criminal, no prior felony conviction whatsoever. Following the submission of my motion, I did read the people's response, which I guess there's been allegations that my client had contacted the complainant subsequently. Now, I just found out today some transcripts. Obviously, people address this. Some of the language that was used during conversations, I don't have phone conversations myself, but I will admit, Judge, that it seems that my client had contacted the complainant even after the bond. And so I say this, Judge, and again, I know it seems like my client is kind of throwing up his middle finger to the court.
Oh, yeah. Yes.
But Judge, I just would state that this young man, I think he understands now that the court orders are serious, that the court orders him to do something it means. So Judge, I'm just asking, I guess, for some leniency to trust that Mr. Hankey will comply. He had a $75,000 cashier bond that he was able to post to a bondsman. The only thing I can ensure that if the court were to give him a second chance, he would not violate his bond, even if the bond is a house arrest with strict conditions. So, Judge, I am asking the court to reinstate his bond, and if the court is unwilling to do so, I would at least ask that his phone privileges be allowed back on to at least contact family. Judge, he's never had any contact with his family, his children. He hasn't been able to contact his dad. Caretaker for. So at the very least, the restriction of his phone privileges to contact them.
All right. Well, before I hear from the people, counsel, let me just say, you came in here the first time, and well, let me start with this. Where's our tether?
My understanding, Judge, I thought community corrections still had it. I thought they had become.
He cut the tether off. We haven't seen it. And I know you made the representation to the court, but I know you wouldn't have personally known that. I'm sure that came from your client or something along those lines. We don't have the tether back. Then, and I get you're making the representation saying your client's going to follow what the court says, but I don't know if anything can be as shocking as walking into a court free, your bond gets revoked, you get put in jail because of something that you've done, and then you still go about violating the court's order.
Even the defendant's own attorney acknowledged the optics of the situation. openly stating that it appeared as though his client was blatantly disrespecting the court. That observation was difficult to dispute. Judge Simpson's response, layered with clear frustration, underscored just how seriously the court viewed the violation. It's hard to understand how someone could remove a tether and genuinely believe they were outsmarting the system. Bond operates on trust, an understanding that the defendant will follow the court's rules. Once that trust is broken, it's not easily restored. Yet here, the defendant seems to treat the violation as if it were a reversible inconvenience rather than a fundamental breach. The combination of arrogance and immaturity on display makes it difficult to imagine any judge concluding that this individual would suddenly comply with conditions moving forward.
I'll be honest with you, counsel. I mean, I get what you're saying. I don't have a problem giving people chances. I just don't know that this is the one to give a chance to. Because he just hasn't done anything the court's asked him to do. Ms. Senda.
Your Honor, I will rely mostly on a motion. However, in listening to his jail calls, he has 45 total calls to one number after his privileges were revoked with different pins he's using. Then to the other number, we have 23 calls that were completed since his privileges were revoked with different pins. And in one of these calls, as recently as Monday, there were a few memorable quotes that I heard in the calls, such as, "There's not shit in this world that's going to stop me from talking to you, man. Nothing in this world's stopping me from you. I don't give a fuck what nobody says about none of that. I'm going to be calling until my court date. They're not going to do shit. At the end of the day, they can't do shit. I'm going to talk to you till I can't talk to you no more. I'll be home. I'm not worried, man. I know I told you this is about to be my last call, but I'm not stopping shit. I'm not stopping nothing." And then, why stop now if they already know? So I have extreme concerns that he cannot follow court orders, considering he cut off his tether, continued flagrantly calling the victim with other pins, both numbers, acknowledging in some of the calls that he should not be contacting her, and continue to contact her. He just cannot abide by any of the court orders that are set before him. So I have great concerns, and especially given the violent nature of this case as well.
Anything else, counsel? I mean, counsel, does your client want me to just request to the jail that they put him in solitary so that he has no contact with anyone, can't use their PIN number? If he thinks we can't do something, and if particularly if you're going to look at this judge and think I can't do something, young man, you're going to learn a big lesson.
So I definitely don't want that. My client.
Well, he needs to, and I don't mean to interrupt you, counsel, but he needs to understand. You can say all that stuff. You are not that big, not that bad. Now, if you want to play with me, this is the kid say, mess around and find out. I guess that's not the quote, but yeah, it's close, but I did pretty good. I said it okay, right now. All right.
So just, if I may, just briefly, my client would like to.
Go ahead.
I want to apologize. I don't think I'm being bad at all. It's very about myself. I can't say that I'm not in here for nothing. You know, I obviously think I am. Yeah. I just want to apologize. Like I said, I'm not being bad. I don't want to hear it. You know, truly can't please so much. Please. All that matters.
I have no problem showing mercy to those that deserve it and have earned it. You have not. Motion for bond reduction or any change is denied. His bond will continue as revoked.
Thank you, Judge. And for the record, this is also, from my understanding, the PCC.
Yes, sir.
Move forward with a plan.
Is all discovery complete?
It is. And I would ask if possible, whatever it is, if possible.
People have their witnesses available on the first.
We'll do our best, Your Honor.
Preliminary examination in person will be set April 1st, 2025, 9 a.m. in person before Judge
Harry.
Perry.
And Your Honor, I did want to make it clear where I did contact the jail yesterday, and they have blocked both victims' new numbers and old numbers, so there should not be any more
calls coming through. All right. Thank you.
Thank you very much, Judge.
Thank you, Your Honor.
To be candid, I find myself agreeing with the judge's position in this case. The defendant has demonstrated, through both his actions and his attitude, that he's unwilling to follow court directives. There is little reason to believe he would suddenly change course. His continued contact, despite being explicitly told not to, and his apparent belief that the court would not enforce consequences, elevate this from mere arrogance to a potentially dangerous situation. It's clear why the judge has little patience left. Removing a tether alone is serious, but the more concerning issue is the defendant's apparent failure to recognize the authority of the court he is standing before. His apology, delivered only after facing consequences, comes across as performative rather than sincere. At a certain point, warnings must be backed by action, and incarceration, without privileges, may be the only measure that reinforces accountability. Thanks for watching, and take care.